Welcome to part 2 of our Introduction to International Criminal Law. In this recording I want to deal with international crimes in outline. So what I'm going to do is introduce the core international crimes that are prosecuted before international courts and tribunals, and I also want to talk a little bit about the crime of torture. So I'm going to talk about war crimes, aggression, genocide, crimes against humanity, and then we'll come on to the question of torture. So to begin with war crimes, of the crimes that can be prosecuted before international tribunals, war crimes is probably the oldest and least controversial category. But there are a number of different concepts we need to untangle here. First, we need to note that the law of war crimes begins with what's often called the law of armed conflict or international humanitarian law, LOAC or IHL. These bodies of law regulate the conduct of states in the course of a war. And crudely, we can think of these bodies of law as laying out the rules of the game. War is to be conducted according to certain standards. Certain acts are not to be engaged in by the participants. In their origin, these rules are basically non-criminal. They are rules of state responsibility. They are rules about what states may and may not do on the battlefield and in the course of a war. Therefore, not every breach of LOAC or IHL constitutes a crime. When we think about the law of war crimes, the major offences found in international criminal law are the grave breaches of the Geneva Conventions of 1949, applicable in international armed conflicts. So there are a number of things we need to unpick there. First, obviously, the Geneva Conventions are a form of treaty law, and this concept of international armed conflicts is significant. These are wars between states, and are sometimes referred to again in an acronym and jargon-heavy field as IACs. So at the very least, by 1949, we have agreement that there are certain crimes that are applicable in international armed conflicts. But this is a limited body of breaches of the Geneva Conventions, only the most serious. Now, there's a long debate about what law, and indeed whether any of it should be criminal, applies in conflicts between states and non-state actors. For example, rebel groups, or where the conflict is simply between non-state actors, so rebel groups or insurgencies. So these conflicts are called non-international armed conflicts. So if one of the participants is not a state, we are dealing with a non-international armed conflict. So how did the Geneva Conventions deal with this issue? Well, it was very controversial whether there was any international law that applied to such conflicts. Many states contended that these should really just be law enforcement scenarios not regulated by international law. However, a limited body of rules was placed within each of the 4 Geneva Conventions applicable to such non-international armed conflicts, and in each case that limited body of rules was placed in Article 3. Thus there is reference to the provisions of Common Article 3 of the Geneva Conventions of 1949, which apply to non-international armed conflicts, or NIACs. So that's our starting point. If we look to 20th century treaty law, there's only a limited body of crimes applicable in international armed conflicts, and a limited body of rules, none of which appear to be criminal, which apply in non-international armed conflicts. So that's treaty law, but of course we also have customary law. And the International Criminal Tribunal for Yugoslavia had jurisdiction to deal with violations under the laws and customs of war. So it clearly had jurisdiction over customary law offences, which meant discerning what those offences were. So the ICTY generates a great deal of case law along these lines, and in particular finds that breaches of Common Article 3 in non-international armed conflicts constitute crimes. Now, many of the developments in this field that are started by the Tribunal for Yugoslavia are later codified in the International Criminal Court Statute, which finds that there's an extensive list of customary rules of international criminal law that apply in either international armed conflicts or non-international armed conflicts. So generally speaking, a war crime involves 5 elements. First, there has to be an act of prohibited conduct, such as murder, torture, rape, and so on. Second, that conduct has to be committed with the relevant intent. Third, the victim of that conduct has to be a member of a protected group, and typically those are civilians or prisoners of war. So the intentional killing of a combatant in hostilities is clearly not murder. That is one of the acts that war inherently involves. The intentional killing of a civilian who is not participating in hostilities or a prisoner of war who poses no immediate threat would be potentially the crime of murder. Fourth, that offence has to occur during the course of an international armed conflict or a non-international armed conflict. So this is often referred to as a contextual element. Other than having the prohibited act and the prohibited mental state, it has to occur in a particular context. And finally, there must be a sufficient nexus between the conflict and the crime. So usually, a war crime will be committed against a member of a protected group by a combatant, and the combatant's ability to commit the crime, or the decision to commit the crime, or the manner in which they commit the crime will be influenced by the context of the conflict. So, for example, sexual offences committed against a prisoner of war could occur as effectively an act of abuse of authority under the colour of being a combatant in a conflict, in which case there is a clear nexus between the offence and the conflict, and it's clearly a war crime. The more controversial question has always been the extent to which civilians who are aiding the war effort might be implicated in war crimes. And usually this requires some connection between the civilian and one of the parties to the conflict, and typically it needs to be a fairly direct connection. So in the Pol case, POHL, which was prosecuted after the Second World War, industrialists who contributed to the war effort and knowingly used effectively slave labour that was provided by a party to the conflict committed a war crime. Taking advantage of the chaos of war to murder your neighbour in order to obtain their property has a far less direct connection with parties to the conflict and is unlikely to be a war crime. Now, a couple of things we should note in this very general introduction to war crimes. First, contrary to what often seems to be reported in the media, we need to note that it is not per se a violation of the law of armed conflict or international criminal law if civilians are killed in armed conflict. Not every civilian death in war is a war crime, and indeed most will not be. Under the principle of proportionality, an attack during an armed conflict can be carried out or can be continued, even if it is foreseeable that it will result in civilian deaths, so long as those deaths are proportionate to a legitimate military objective. Civilian deaths will only be a crime if civilians are deliberately targeted, if they are themselves the object of attack. So if it is strategically important to subdue and capture a particular city, and the best military means available for doing that is bombing the city, then so long as that bombing campaign will not result in disproportionate civilian death, it will remain legal. Similarly, this same principle of proportionality extends to so-called civilian objects, so objects that are not per se part of the military war effort. A classic example might be some piece of dual-use infrastructure, like an electricity supply, a bridge, or water. There will clearly be damage in a general sense to civilian infrastructure and possibly even civilian casualties that might result if you attack a water supply or an electricity supply. But so long as the military advantage is proportionate, then the attack is not illegal. And that advantage might be obtained in a completely different area that is quite remote from the place where the attack occurs. We should also note that the law of armed conflict is often referred to by the Latin title, the jus in bello. That is, this is the law that applies in war, and it applies to all parties, no matter whether the war was lawfully or unlawfully started. So if a war is commenced illegally, that will involve a violation of the jus ad bello, the law on the recourse to force, and it may even constitute the crime of aggression. However, it does not mean that every act that follows is a crime. The law that applies in the conflict is quite distinct from the law governing the recourse to conflict in the first place. So, even if a war is illegally commenced, ordinary soldiers and indeed their superiors are not automatically guilty of war crimes. This leads us on to the crime of aggression. So this was prosecuted at the Nuremberg International Military Tribunal, and at that time, in 1945, it was regarded as the crime of crimes. Commencing an aggressive war was seen to be the greatest evil that humanity could commit, whereas now we would probably attach that label to genocide. So aggression was the crime of waging a war in violation of international law, in violation of peace treaties and the like in force. And convicting members of the Nazi leadership of that offence was generally seen as unproblematic. However, it was difficult to secure agreement on a definition of aggression after the Nuremberg trials. So in a sense, the factual case was against the Nazi leadership was seen as self-evident and overwhelming, and a precise legal definition thereafter proved difficult to agree. And indeed that controversy continued into the negotiation of the Rome Statute of the International Criminal Court. So in 1998, when the Rome Statute was concluded, there was effectively a placeholder provision. The court was given jurisdiction over aggression, but no power to exercise it until a definition was reached. That is, in the negotiations, they still couldn't agree what aggression meant. They could agree it was a crime, but they couldn't agree how to define it. So they deferred the issue in order to avoid having that question, as it were, kill the court. And the compromise reached was that there would be a review conference after a certain period of time elapsed once the court statute came into force, and at that review conference there would be the opportunity to come up with the definition. And what we saw at the International Criminal Court Review Conference of 2010 in Kampala was that a complex definition of aggression was added to the statute, but its implementation was deferred. It will still be some time before the court effectively has jurisdiction over that. Now, I won't go into that definition in great detail. It leads us too far into the law on the use of force that is covered later in this course. I will simply note that it involves recourse to force in violation of international law, but it needs to be a flagrant breach of international law. Not every illegal use of force will constitute aggression, and more importantly is the question, who could be prosecuted for aggression? And generally it's agreed to be a crime of leadership. Only those in a position to control state policy can commit aggression. Right, let's turn towards the current crime of crimes, genocide. So first, we have this view now that genocide is the supremely evil crime and has always been acknowledged as such, and that's simply not true. As we've said at the Nuremberg International Military Tribunal, it was aggression that was regarded as the supreme evil. The Nuremberg International Military Tribunal Charter did not even list genocide as a crime, and in terms of the factual matters pursued at Nuremberg, genocide played only a relatively minor role in the trial. Now, the way the crime of genocide works is it is focused on, again, a list of prohibited acts which include but are not limited to murder, carried out with intention, as with other crimes, but further than that, carried out with an intent to destroy in whole or in part a protected group as such. So, genocide requires not only intent to kill, or intent to commit one of the other covered offences, but it has this further special intent requirement, sometimes referred to as a dolus specialis. So ordinarily, we think of crimes as requiring intent, but criminal law itself is not usually concerned with motive. Criminal law is ordinarily concerned that you intended to commit murder, but not why you intended to commit murder. An explanation of why someone might have a motive to commit murder might make it easier to convict them, but it isn't a necessary ingredient of the crime. Genocide uniquely requires this special intent element. And we'll come back momentarily to genocide in much more detail as it forms our principal case study. Now, there's a further debate that's worth flagging at the moment as to whether genocide also requires that the individual act of murder or other prohibited acts must fall within a wider pattern of genocidal acts. So the question here is, does genocide, like war crimes, have a contextual element? And that's a debate we can have on the authorities, and we will turn to that in a moment. Now, crimes against humanity could be thought of as similar to genocide, but a broader category. So essentially, crimes against humanity require prohibited conduct, so it could be murder, torture, mass killing, and so on, carried out with intent, so the individual act has to be carried out with intent. But the important part then is the crime in question forms part of a widespread or systematic attack against a civilian population. It therefore requires a contextual element, this widespread or systematic attack. A wide range of offences can be committed as part of a crime against humanity, including murder, enslavement, forced deportation, improper imprisonment, torture, various sexual offences, enforced disappearances, and so on. A complete list is found in your textbook. However, the important thing to note for our purposes today is this requirement of a contextual element, that the crimes occur as part of a widespread or systematic attack against a civilian population. Now, in terms of this idea that there's a contextual element, there has been controversy over how it should be defined. For example, at both the Nuremberg International Military Tribunal and the International Criminal Tribunal for the former Yugoslavia, there was a requirement that crimes against humanity occur in the context of an armed conflict. Now, that is generally seen as no longer a requirement of a crime against humanity. Indeed, essentially these are meant to be crimes that a state or even an organisation can commit against a civilian population in peacetime. So the ICTY has said in its own case law that the requirement of a link to an armed conflict is a feature of its statute and not a feature of general customary international law. But one of the difficulties has been that this crime has evolved principally through its definition in the statutes of international courts and tribunals, and all of those tribunals have tended to take a different approach. But the definition given in the ICTY statute was very thin, so it had to be elaborated in case law. And critically, the ICTY said in Kunarak that this widespread and systematic requirement had two elements that could be proved in the alternative, so either widespread or systematic, and widespread refers to the large scale of the attack and the number of victims involved, while systematic referred to the organised nature of the violence and the improbability that these attacks are merely random. So the key feature here is that the ICTY's wording was widespread or systematic. These were alternative requirements, and this proved controversial in the Rome negotiations for the International Criminal Court Statute, because the idea that crimes could be merely widespread and constitute a crime against humanity led some delegations to fear that simply a crime wave could constitute a crime against humanity, and that was clearly inadequate. An entirely random, though widespread pattern of crime should not be able to be called a crime against humanity. So while the ICTY case law formulation was retained in the end, widespread or systematic, Article 72A of the ICC statute defined the term attack to require that there be a state or organisational policy to commit such an attack. That is, these widespread or systematic crimes had to be committed pursuant to a state or organisational policy. So the ICC statute tries to address that criticism about potentially random acts by injecting this element that there be a policy. Now, whether a policy is a required element of a crime against humanity at customary international law remains controversial. The ICTY case law regards evidence of a policy as very helpful, but not necessary. The ICC statute fundamentally requires it. So one question we could then ask ourselves in applying the law to a real scenario would be, would the 11 September 2001 attacks on the World Trade Center in New York constitute a crime against humanity? They killed nearly 3,000 people and resulted from the criminal plan of the group Al-Qaeda. Well, let's think it through. There were 3,000 individual intentional deaths, so acts of murder, so there's clearly a covered crime. Was it widespread or systematic? Well, it was certainly a large-scale attack with an extraordinary number of victims. Widespread doesn't necessarily mean geographically widespread. And it was systematic in the sense that it was the result of an organisational policy, that of the group Al-Qaeda. So on any definition it would seem to be quite a fair candidate for a crime against humanity. Let's turn briefly then to the crime of torture. Torture is not of itself a crime within the jurisdiction of any international court or tribunal. However, it's both a crime under the Torture Convention, generally punishable by national courts, and torture may be committed as one type of war crime or crime against humanity. So it's worth reflecting on briefly. Torture is defined in Article 1 of the Convention Against Torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of, or with the consent or acquiescence of, a public official or other person acting in an official capacity. The three key points to pull out of that is that torture requires severe pain or suffering, which has to be inflicted for one of these prohibited purposes, and this has to have been done with the consent or acquiescence of a public official. Now, while we've said torture may also be committed as a war crime or a crime against humanity, we should note that the ICC elements of crimes vary the definition somewhat. Now, the first thing we note is that for either a war crime or a crime against humanity, there's a contextual element, which would be additional to the Torture Convention definition. So for a war crime, there has to be a sufficient link to an armed conflict, and for a crime against humanity, torture has to be carried out as part of a widespread or systematic attack against a civilian population. But even beyond that, there are variations. First, torture as a crime against humanity requires two things: the severe pain or suffering requirement, and in addition that the victim be in the custody or control of the perpetrator. It doesn't appear to require a prohibited purpose, and it doesn't require the involvement of a public official. Somewhat differently, torture as a war crime does require severe pain and suffering and also a prohibited purpose, but not the involvement of a public official. And it may be that both offences have been designed to avoid the requirement of a public official at least, because very often international crimes might not be committed by a state. They might be committed by an armed rebel group, for example. But torture under the Convention, or possibly even as a war crime, is something we will come back to when we consider a little later on some real cases and theories of liability that allow us to connect individual offenders with the commission of international crimes.